New motions are before the Idaho judge overseeing the murder trials of the Chad and Lori Vallow Daybell. Chad and Lori are charged with the murders of two of Lori's children and Chad's former wife, Tammy. Now, the couple made headlines for refusing to divulge the location of the children after JJ's grandparents reported them missing.
Lori, Nate Eaton with East Idaho News. Can you tell me where your kids are? Where are your kids?
No comment.
No comment? They've been missing for 4 months. You have nothing to say? You're over here in Hawaii? Where are your children? Yeah, why don't you just give us a comment? Just tell us where they are. Chad, where are Lori's kids? What happened to Tammy, Chad? Can you tell us what happened to Tammy? Why have you guys been in Hawaii for so long? Listen, just tell people what's happening. There's people around the country praying for your children, praying for you guys. Why don't you give us answers?
That's great.
That's great. That's great that they're praying for you, praying for your kids. What? You have nothing to say? Did you do something to your children? Are your children still alive? That's a simple question. I've got 3 kids of my own. I can tell you every minute where my kids are at. Where are your children?
Now, the children's remains, as we know now, were later found buried and partially burned on Chad's property. Now, Chad's attorneys are hoping to sever the trials. John Pryor laid out a number of reasons for the severance request, including gender bias in sentencing, and he also laid out what could be the first inkling of a break in the bond that the two seem to have regarding their defense to these murder charges. In a portion of the motion, he wrote, based on the allegations in this case, one of the plainly available defenses would be to demonstrate that Ms. Vallow and her brother Alex Cox were responsible for the crimes alleged and that they acted as part of their own conspiracy that did not involve Mr. Daybell. As part of that defense, Mr. Daybell would seek to introduce the prior bad acts of both Ms. Vallow and Mr. Cox, as well as evidence regarding their relationship and the death of Mr. Cox. In the past statements of Mr. Cox, Ms. Vallow's prior bad acts would bear upon motive, intent, and plan. Now remember, the judge has already denied a previous attempt by Daybell to sever the cases, citing that all the evidence is essentially the same for both defendants. All right, still with me, criminal defense attorneys David Bruno and Francis Johnson. Francis, I'll start with you. A compelling motion. I read through it, about 30 pages or so. He also cites gender stereotyping as one. He cited some incredible numbers that 808,581 men versus 175 women have been sentenced to death. This is a death trial. But regarding this severance and this issue of the two pointing the finger at each other, or at least Chad pointing the finger possibly at Alex Cox and Lori Vallow, seems like a compelling argument to be made here for severance.
I agree. The motion was thorough and quite comprehensive. So kudos to the team for putting that together. And I think that Eighth Amendment issues raised are quite serious because this is a death penalty case. And of course, it is different in kind and character and treated so under the law than other cases. And so at the end of the day, I think the rationale of the court in that, the evidence is essentially the same, and that the defenses are mutual, and that it's the possibility of confusing jurors as it relates to this evidence are a tough nut that they're going to have to crack, even with this compelling motion they put forth today.
Interesting. Now, the plot thickens here, David, because we've all said we've been waiting for that shoe to drop, that somebody was going to point the finger at each other. And we always thought Alex Cox was a great guy to be out there for them to point it at. Alex Cox and Lori have had a weird relationship. I want to play some sound from Alex's ex-wife, Debbie, about that relationship. This is the stuff that Chad's attorneys are going to be able to work with. Take a listen.
How did Alex talk about Lori?
Well, he was a really, really protective big brother, but he also talked about her being hot, and he sexualized her quite a bit. But he was just also really, really protective. we lived in the same apartment complex for a while, and it just kind of seemed like Alex just chased after her a lot.
Did you ever suspect anything more going on other than their playfulness, I guess?
Well, I asked him because he did touch her breasts and things, but they were allowed to do that in their family. So to him, he didn't think it was weird. He thought I was weird for thinking it was weird. And so we talked about that stuff a lot, but I didn't think he was sleeping with her.
Okay.
I just thought he had the liberty to touch her.
Did you ever confront him on that?
Yeah, I did. And I confronted him on, what about when we have kids? Would you allow that between our kids? And he just didn't think that there was anything wrong with what was going on.
All right, David, Bruno certainly raises some eyebrows. Again, as I said, a lot for Chad's attorneys to work with here. The question is, do you think the judge here should or will allow severance?
I do, Michael, and we are frequently on the same page, and literally I'm on the same page of this brief as you. And just one step further on this, what Mr. Daybell is asking is to introduce evidence of prior bad acts against Vallow and Alex Cox. Now, what that means is potentially they're going to be pointing the finger at these two, but they want to introduce evidence that would not be admissible against Ms. Vallow. So they're going to be prohibited from entering evidence if the cases remain joined. And that's the antagonistic defense argument that's being made in this brief, which I agree with. I agree with my esteemed counsel, as well as you, Michael. It's a great argument to make when you're trying to get evidence into a case that would not be admissible if it were not joined. So I think that's the best argument in the brief.
Absolutely, I agree with you. He also, part of this brief, he wants more time, Francis, because he basically says, look, this is not only one trial, it's actually two. It's a death penalty case. I got to prepare for the case on the merits. I also have to prepare for the penalty phase, should it come to that point, which is going to take a lot of time. He says he's just getting started on that. He wants to move that January date to October of 2023. Previously, he had argued to start it in October of 2022. I wonder if the judge will hold that against him. But at the end of the day, what do you think about that argument?
I think the time argument is a good argument to make. Again, the finality that comes with a death penalty case and all of the safeguards that we have to ensure for a defendant would mean that a delay until October wouldn't be something that I think would be extreme in a very complex case like this. You know, the motion again is a real gem. It's what I call a kitchen sink motion. It throws in the first and second and third and eighth and 14th and fifth and sixth amendments to the Constitution. It's a kitchen sink motion. I think the time component is a good component as well, and we'll see what the court does.
Hey, David, you know, I don't think the prosecution is going to protest too much. They originally wanted an October 2023 date or a September 2023 date, and the January date was actually a compromise between what Daybell's attorney was asking for in that October 2022 and the September 2023. He said, okay, we'll do it in January 2023. So they might not protest too much.
Yeah, but that all depends on the severance too, because Vallow has argued for speedy trial. She wants a quick one. So guess it's not the strength of the argument, but I guess practically speaking, if there's a reason to sever and Vallow wants her trial sooner, well, let's push her first. Let Daybell and his attorneys prepare. And I guess that's going to be a huge advantage for Daybell if he could get it severed and then have Vallow go first, because then they get a preview of the state's case, especially since the prior ruling says that the evidence is similar.
Absolutely, that doesn't change, right? So if she gets tried, the evidence they're going to see in that case is ostensibly the evidence they have against Chad Daybell, so that would be a huge advantage for them. So again, we don't know how the judge is going to rule. We're expecting arguments on that for on October 16th, I believe the date is. Of course, we're going to keep you updated.